Good morning. Captain Matt Edwards retired here with another one of these Facebook Live broadcasts. I'm going to take on the Charter of Rights and Freedoms today, at least in part. And bear in mind that I'm not a lawyer, but I've done a lot of legal reading. Now, in preparation of this particular broadcast, I posted the link from the Department of Justice site for the Constitution Act, so you can have a look at it. Now, I'm going to have it up here as well. So, my understanding of the Charter of Rights and Freedoms is that the government brought the Constitution over in 1982 from England, where it was the British North America Act, and they consulted with the provinces and they decided to create the Constitution Act instead in 1982, with the feds and the provinces getting together. Now, the Charter of Rights and Freedoms is supposed to, based on my understanding, take the values of Canadian society and put them into the law as the first and foremost law, as part of the Constitution. So it was around the time that the United Nations was making a lot of fuss about human rights. So the Charter of Rights and Freedoms is basically Canada's human rights stuff. Now, the various provinces have had their own acts, but this was the federal act that came in and the provinces cooperated with it. Now, the very first part says that, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Now, you see, I kind of am more of an American type thinker, that there shouldn't be any limits on our personal freedoms. If you could say that it's better for everybody if we restrict this or that group's rights and freedoms, then they can just say it whenever they want. That's my opinion. If you have it black and white that you can never infringe someone's personal freedoms, some personal human rights, I think that'd be better. But evidently the provinces kicked up a stink back in '82, and they insisted on the notwithstanding clause, it is my understanding. Now, number 2 is one of the most important ones as far as I am concerned. Fundamental freedoms. Now, fundamental means basic. Freedom, well, we all should know what freedom means. No one telling you what to do. Everyone has the following fundamental freedoms. A, freedom of conscience and religion. Now, I brought up the issue of conscience when I asked Canada Revenue Agency to delete the T4A, take out the T4A sent in by Manulife, because I suspect they're doing something illegal. And it weighs down my conscience to have them do that. So I sent in a request and I said, under the Charter of Rights and Freedoms, I have the right to act in accordance with my conscience. And can you take this off, because I suspect these people are up to no good. Because they're sending in false T4As. They're putting on Manulife on the form, when really it should be Canada or not sent in at all. I don't know if someone might say I'm just putting it in the context of the Charter, but the Income Tax Act is an act of Canada and it has to conform to the Charter. That was my point. Now, religion's simple. Well, not simple, but you want to be Christian or Jewish or whatever, that's your choice. The government can't have a state religion. Freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Now, Canada didn't just have freedom of speech. They put it into more complex terms. Now, think about this, though. One of the biggest problems I have is when the government intrudes inside our head and they say, do you get this? What is your income? Like, they're basically seizing your personal information from your head that you ought to have the right to keep to yourself, because it's none of their goddamn business, right? You had the freedom of expression, you have freedom of speech, sort of, but you also have the right to silence. And the government can only ask you things, if it's relevant. Anyway, 2C is important. I came across it when I was researching my union status with Canada Revenue Agency. Our property requires nothing. Well, I agree. It is our property. Now, the Bill of Rights protected our property, and it said it could only be taken away with due process. The Charter doesn't do that. Now, the one I was talking about, freedom of peaceful assembly, when I was looking up belonging to a union, because there was a big racket with my union, the Canada Revenue Agency put me into the Professional Institute of Public Service Canada, but they sent my dues to the Public Service Alliance Canada, which caused a big mess because my dues were going to the wrong union. Now, the thing about that is, when I was looking up some stuff about that in court cases, I found that someone argued that they shouldn't have to belong in a union because they were being forced to associate with those other people. And, I don't remember the exact outcome of the case, but they basically said that, the freedom of association doesn't preclude not wanting to be associated with something or something like that. Anyway, I remember looking it up at one time. But the thing about this is, think about Veterans Affairs and the Department of National Defense. You're in the military, you have to associate with other people. If you're in Veterans Affairs, you have to associate with people at Veterans Affairs if you're in the rehabilitation program. So this is a kind of a new thought. Just as I'm making this talk right here to the phone I'm looking at, my Samsung Galaxy. I'm not an Apple person. And basically, we're forced into association with people. Now, although I plan to do some stuff on support law later, if you go get divorced and the judge says that you had to pay your pension act or your new Veterans Charter benefits, which are supposed to compensate you for your injury, they are forcing you to associate with your ex-wife or husband. I believe that's a breach of our freedom to associate. That unless somebody can point out a case where it came up before, and the court said that, this is not really a thing, why should the government force a person who wants to be shucked of the other person? Now, I don't think it's unilateral mostly. A lot of times it's both people want to leave each other. Then why should they have to associate? It can't do anything but harm as far as I'm concerned. It's going to create a lot of animosity and problems in society. That's just my bigger picture take on that, right? Now, the last one, actually, C was the wrong one. D, freedom of association is in D. So Charter Section 2D, not 2C. 2C is about peaceful assembly. Now, in the criminal code, for example, it says that you're allowed to have a peaceful assembly, and they usually start counting at 3, not 2, 3. So if you go have a peaceful assembly and there's 2 of you guys and you're causing a fuss, they can't do much about it under the unlawful assembly law in the criminal code. But they say number 3, you have 3 people, and then if you're doing something unlawfully, if you're doing something that's not right, you can't claim charter protection if you're doing something unlawful, because they say it's peaceful assembly. Anyway, number 6 is important. Mobility. Okay? Every citizen of Canada has the right to enter, remain in, and leave Canada. Now, think about this. It won't be a popular statement I'm going to make, but I believe in the rule of law and believing in charter being followed. Think about any law that might come into effect, like if someone wanted to join ISIS. Okay, so they posted to Facebook that they were going to go join ISIS. And then somebody wanted to pass a law to stop them from leaving the country to join ISIS. Well, now you passed a law that broke Section 6 of the Charter of Rights and Freedoms, and people might look at that and say, well, they shouldn't be allowed to leave. Well, listen, they might change their mind. They might go, get on the plane, and then they might change their mind on the flight. They might land, change their mind before they go join ISIS. So you can't prejudge someone for an action they didn't take, at least in my opinion. Now, if they do go, leave, and join those people and do stuff, throw the book at them. But only when they enter Canada, because you can't pass a law that has extraterritorial application. You can't pass a law in Canada that affects the rights of Chinese or Russian citizens. You can only make laws that affect your own citizens. So the idea that they can make a law that can throw the book at someone for doing some crime overseas, there are practical matters. How are you going to prove that? How are you going to prove it? How are you going to enforce it when laws had to be based on Canada? within Canada's jurisdiction. They can make laws affecting Canadians. Now, it seems to me that they're jumping on the political bandwagon of wanting these people punished, but they never thought about the legal application of the law, at least in my opinion. Anyway, moving on. Number 7. Life, liberty, and security of the person. Now, they put that above the section, but that's called a heading, and in law, headings have no legal force and effect. But it says everyone has the right to life, liberty, and security of the person, and that right not to be deprived thereof, except in accordance with the principles of fundamental justice. Now, fundamental justice means you had to have notice, a hearing, and an independent judge. Those are the 3 principles of fundamental justice. Now, we can deprive someone of their life, according to this, or their liberty, or their security, if we provide, with their legal recourse, their due process. So if Canada wanted to bring back the death penalty, it probably could. Many people might disagree with it. I don't disagree with it. I used to jokingly say, well, the price of a bullet's a lot cheaper than sending someone to jail for $100,000 a year for life. Now, I'm a hawk. I've never said I wasn't. Don't ever confuse me with someone who's liberal, small L liberal, and believing that people should get something for nothing. Like I believe in God, kill them all and let God sort them out if they're our enemy. Okay, that's my personal belief. Now, the thing is that, getting back to my topic, my area of expertise and stuff, Dennis Manouche and I were talking about this a few years ago, and I'm not going to make this my entire show, but security of the person includes psychological security. Okay? Now, that's a very important thing. Now, if you have to have psychological security, you can't have people abusing you all the time. And the government is abusing a veteran because it takes into account things that it has no right to take into account. Now, you take, for example, Sean Corrine. Sean Corrine, leading seaman, retired, served from 91 to 2003, and then, when he became disabled, he's covered under the Pension Act. Now, he's also covered under the new Veterans Charter, and he was part of the Service Income Support Insurance Plan class action lawsuit. You can't tell me that he hasn't suffered psychologically, because the Canadian Forces pension takes into account his Canada Pension Plan disability. The Service Income Support Insurance Plan takes into account the Canadian Forces Superannuation Act pension and the Canada Pension Plan. Then in 2006, he was on the Earnings Loss Benefit Program, but they said, the Pension Act has to come off. And to me, that's a very horrible thing to do for the people at Veterans Affairs, because they're the people that should be administering the Pension Act for the benefit of the pensioner. And the government wrote Section 30 of the Pension Act, and it said no creditor could touch the pension. So while they might say, well, the Department of National Defense is not Veterans Affairs, they could have screwed up. Why in the name of Christ did Veterans Affairs take into account the Pension Act? You can't tell me that's fair. Now, on a technical and legal viewpoint, they used double deduction. The Department of National Defense took into account the Pension Act pension, and the Veterans Affairs Department took into account the Pension Act pension, and I say this is an unfiled class action lawsuit. Okay? Veterans Affairs, in my opinion, can be sued for their using the Pension Act as a deduction at the same time that the Service Income Support Insurance Plan took the Pension Act into account. Now, don't get confused about the Toth class action lawsuit where allegedly that issue was settled, because they made their own bed when they called it a human rights settlement and not a settlement because they broke the law. So Section 30 of the Pension Act said they couldn't do it, and if they broke the law, that would be an act of negligence. So I believe the government can be sued in negligence for breaking the law, and therefore the people will have to get the money paid back to them. I've estimated that China is owed between $600,000 and $700,000. Okay? May sound like a lot, but the Canadian Forces pension has to pay him back for the Canada Pension Plan being taken into account. The Service Income Support Insurance Plan has to pay him because they took the Canada Pension Plan and the Canadian Forces pension into account, when the Canadian Forces pension is protected by Section 83 of the Canadian Forces Superannuation Act and the Financial Administration Act, Section 67. But because the government is having their own pension taken into account, and to reduce their legal liability under the Department of National Defense program, two programs, the Canadian Forces Pension and the Assisted Long-Term Disability Insurance, they're looking the other way and they're condoning illegal actions, which never ends well. If you look the other way and you ignore unlawful behavior, then people are going to become emboldened. And then they're going to keep looking at and poking at and trying to find other ways to break the law because they knew they never had the book thrown at them when they broke the law before. The Royal Newfoundland Constabulary, a local police organization, they have a theory that certainty of getting caught is more important than the punishment. It's not their theory. I'm sure that they came up with it from reading some psychologist or someone, but it's better to know, it's more deterrent to know that you're going to get caught than them throwing a huge fine or a huge jail term at you when you get caught. Don't you agree that that makes sense? It makes sense to me, at least. Anyway, my point is that they're condoning the illegal actions of the government, which is never good. And they try to, I made this point yesterday on this note I made to myself. I said, look at what's happening through the lens of equity instead of the lens of legality. Okay, so if we did that, Sean has the Canadian Forces Superannuation Act pension reduced because of the Canada Pension Plan. That's because of Canadian Forces Superannuation Act Section 15.2b. Now, that's a law. Now, instead of looking at it through the legal lens that the government had the authority to write a law, at least I think they did, and they then wrote a law, and then they applied that law, let's look at that in the terms of equity. Sean served for 12 years. During that time, his service had value. He was paid for his time, and as part of his pay, he had a deduction, a contribution for the Canadian Forces Superannuation Act pension. He also had part of his pay deducted under the Canada Pension Plan Act. So he had two pieces of property established. He had two bank accounts established. They took money off his pay. He could have used that money in the time that he was still healthy enough to serve. But the government passed laws to make him save for the future. Now, then they wrote a law to deduct the value of one pension from the other pension. Now, is that fair? Is that equitable? That's what I meant when I said look at things through the lens of equity. So if you look at what's happening, they wrote a law so they can point out to the law as it being legal. Now, I personally think that we can challenge that under the law as well, because we can ask them, is it under the federal government's jurisdiction? So if we said, instead of, but this is digressing from the lens of equity thing, because I am talking about law, but is it equitable? Is it fair to write a law that's not within your jurisdiction? I could put a spin on it like that. I'm not putting a spin on it. I'm just telling you a way that I can link it back to the equity thing. I think I'm a bright fella. But no one is supposed to make a law outside their jurisdiction. So if the Canadian Forces Superannuation Act, Section 15.2b, is unconstitutional because it affects property and civil rights, because it takes into account the Canada Pension Plan disability, then it has to be struck down. Now, if it's struck down, which is called read out in the common law, so sometimes the courts can read in things that the government should have thought of when it made a law, and sometimes it takes things that the government put in there that shouldn't have been, and it reads it out. So somebody, it could be me, could be somebody else, somebody ought to challenge the constitutional jurisdiction of the government to take into account property and civil rights, which are pensions, because they fall under the province's jurisdiction, you see. Now, just because they wrote a law and they're relying on us to think that because they wrote a law, it has to be obeyed, and therefore we have to lose money, well, again, looking at it through the lens of equity instead of the constitutional lens, well, why should I lose my property on the one hand over here when on the other hand, there's two properties there? And I agree with Arnold. I don't know if they developed this racket on purpose, or if they fell into it and they like the savings, so they don't want to look into it. That's my personal opinion. I think that I don't think anybody got together and they all had a big old powwow, maybe I shouldn't have used that word, or they shouldn't have had a big old conspiracy meeting where they said, listen, let's do this, and screw people over. I think they fell into it because of the common practice, okay? Like, workers' compensation, for example, is not supposed to be taxed. So the provincial government taxes it indirectly by basing the rate on the after-tax income of the injured worker. Now, the federal government did the same thing for the Pension Act. And they think they're on safe legal ground because that's what the provinces do. But if what the provinces do is illegal, Jennings, 1966 Supreme Court of Canada, you're not supposed to have damages taken into account for personal injuries. So the principle is you're supposed to get paid back with what you got hurt. So if you get a damage if you get hurt, your body is capital, then you have to get paid back in capital. That's why, they might not say it openly, but that's why you don't get taxed on damages. I mean, think about it. You're walking down the street. You're walking down not on the street, on the sidewalk. Someone's texting and driving. They swerve, they hit you. You were healthy before. They were a stranger, not known to you, and they only became known to you because they became involved in an accident. They hit you, they hurt you. Now they have a legal and a moral and an ethical obligation to put you back in the same place you were before. Now, if you think about that in terms of the military, if you get hurt in military service, you have to have the same right to be made whole that a civilian has. There's no way that the government can justify that simply because it's government, right? Think about that. Why would you want to have a different rule than what they have normally for a civilian? The only reason could be to save money. Now, I don't disagree with saving money. I love saving money. For example, with the SEP program, if they followed the same process as the Sun Life insurance policy, then they would save money because they wouldn't be making us go to the doctor. They wouldn't be sending paperwork out and mailing, postage. They wouldn't have people reading it, scanning in the computer. Then they wouldn't be billing the government for all this to get reimbursed, the sons of bitches. I think that's what's happening. Now, to do that simpler and cheaper would be better for everybody. And it's the same thing with all the stuff I'm doing. Keep it simple, right? And I agree with Arnold again. I mean, listen, a few years ago, myself and Arnold were talking about all this stuff, and I put out a petition on change.com or something like that. I was shocked when I got a call, first of all, from the people at change.com, and I thought it was a scam, and I was there not wanting to give him any information or whatever. Then finally he convinced me that he was legitimate. He was someone that worked for the organization, and he saw my petition, and he said, you know, I'd like to help you. I'd like to suggest a few word changes here and this and that, and maybe I'll do some advertising for it. By Jesus, that thing went from a couple of thousand signatures to 25,000 in 1 day or 2 days or something. I thought, I got really hopeful that the shit was going to hit the fan, the government was going to have to start fixing all this stuff. But it petered out at about 28,000 signatures. That's my most successful petition. I've done about 30 or 40 of them. And that was my most successful one. All right? We need a public investigation. Okay? If they do it privately, it's like they're hiding something. That's the way I would put it. And I think Arnold and Donald Bohan, another fellow that I tag a lot in my Facebook group, he used to be a lawyer. He was a soldier as well, so he's a veteran. And I think you have to do one of the main functions of the law system is not only to show that have justice be done, but to show that justice is done. You see, so we have to see, and justice must be really done, but we must also perceive it to be done, right? So anyway, let me move on a bit to number 8, because you know, I mean, I'm trying to make these broadcasts short. I was planning on hopefully at least only half hours out of the day, but I had a couple of topics. The charter, let me just do some broad strokes. The government, having written the charter, cannot contract out of the charter. So if we look at the Service Income Support Insurance Plan, it's an alleged contract. I don't say it's a contract at all. The reason I say that is because with any contract you have to have some form of negotiation. If you have a contract that you had absolutely no negotiation, how can you call that a contract? I kind of consider it a quasi-law, that they have an insurance contract on paper, but they act as if it's a statutory law, and they actually change it every so often. And I came across one of these from 2016, and they were proposing changes for 2018. So they put it out there 2 years before their changes to the policy. Now that's kind of what the government does with the Canada Gazette and the new Veterans Charter. So I think that they act as if this is a law and not a policy of insurance. Now, yesterday, and I'm trying not to tread on too many toes, but I spoke to Lieutenant General retired Cuppins. And it was only a short call. He was at lunch, out to lunch, I think. And I was trying to see if I could find a way to dig up some old reports. There's a report called the Stowe Report from 1997 and the McClellan Report, Lieutenant Colonel McClellan. And so I asked him if he knew him. Now, he knew McClellan, but when I said if he could try to figure a way out to put me in touch with him so I could ask him some questions from the report and see if I could get a copy of the report, he said, well, he's probably dead because he was actually older than I am, he said. Now, Lieutenant General Cuppins retired is in his 80s. He was in the Air Force. I've had many chats with him. He's a great fellow to talk to. But I'd like to put my hands on these reports because, for example, Tom Anderson, Corporal Tom Anderson, retired over in Cape Bray, Newfoundland. He had a copy of the preliminary report, and he sent me a couple of pictures from it. And I was shocked to see that the report said that many people falsely believe that the Service Income Support Insurance Plan is an insurance program. Now, what would give us that idea when the name says Service Income Insurance? You know, I mean, don't we have a legitimate expectation that's a legal term to expect it to be insurance when it has insurance in the name? You know? So I wanted to confront the man. I presume he's out of military service now, but he could be dead. But I wanted to ask him, why did he say that, people had this false expectation that it's an insurance when it is a fucking insurance, So what they need to do, for example, and I'm not exactly getting off topic, but you need to have the SEP program acting like insurance, and I know what happens in theory on insurance because I read about it in the Sarvanis Supreme Court of Canada case. And the Canada Pension Plan was described as being insurance. And they said that when insurance has the risk that you insure against happen, then you get paid. Now, where's my SEP? I am not getting paid my insurance. Hey, I think I just remembered my point from last night that I forgot to write down. I was putting on my Facebook that I came up with an idea, I forgot to write it down, and then this morning I was going blank about what it was. Now I'm doing all this talking about it, and then I'm forgetting about it again. But I think it had to do with the SEP program and the fact that I had several pieces of correspondence from Veterans Affairs about the SEP program. Now that shouldn't be too surprising because they have a program arrangement in place. But I was thinking about it in terms of my experience. Okay, so I was fighting with the Service Income Support Insurance Plan Administrator, Manulife, and they were telling me I had to be hurt in service. And then I said to them, over a period of time, not just once, how the fuck am I going to prove I was hurt in service if I have an invisible disability? I become involved in a field training exercise accident where a vehicle flips over. I lose 2 legs, and I got no legs. You can see that. And, I don't have to prove it because you can see it with your own eyes. I have some invisible disability caused by whatever, and then I put in for an application. Then how am I going to prove that I was disabled in service? It's a catch-22. They can't do it. I can't do it. It's why they don't pay very many reservists. They require you to be hurt in duty, but then you can't prove it because, well, what is the threshold? What is the onus of proof? Now, on that note, I was talking to Donald Bohan via instant message, and he was asking about onus, and I was asking him, are you talking about burden of proof, onus of proof? Because Paul Franklin and I were discussing that several years ago because he thinks, as well as I do, that they should have to prove that we weren't hurt in service. Not that we should have to prove that we were hurting service. That would be called reverse onus. And I think that's the fair way to do it, because, let me tell you why legally. Let's say you work for an employer like Canada Revenue Agency and they wanted to fire you. If they want to fire you or demote you or give you a financial penalty, it isn't up to you to prove why you shouldn't have that happen. They have to prove why it should happen. So if they allege something, they have to prove it. Now, think about the burden of proof under the Pension Act and probably the new Veterans Charter, although they don't really apply it. The burden of proof should be on them, not us, okay? You take a person who goes in and asks for a disability award or a pension, and they go to their doctor and they talk to the doctor, and the doctor accepts what they say, and then they fill out the form. The doctor didn't have a gun held to their head. The doctor could have said, if he had a story being told to him by a veteran, he could have said, listen, I've listened to you tell me this story, and I don't think that this was caused by your service, and I am not going to sign that form. Now, Veterans Affairs gets the signed form from the doctor where they agree with you, and then Veterans Affairs rules against the professional who you aren't paying. I mean, the pay from that person, the doctor, is coming from the government. So he's not your doctor, really. And then the government is just ignoring the doctor's opinion. Now, that is crazy. That is completely crazy. Now, it's like the Canada Pension Plan. They have nurses that overrule doctors' opinions. Canada Pension Plan doesn't have doctors working for it. They have nurses. They hire nurses to review the applications. Now, we go to a doctor. We get a doctor to fill out the form. Doctor could easily say, listen, you're wasting your time, and I don't think you're too disabled. I'm not going to give you false hope by filling out this form. I'm not going to do it. But they do. Now, if they fill it out, don't we have a right to expect the government to accept the doctor's word? This is crazy. The whole system is designed to save money, and designed to save money at our expense. Anyway, getting back to my point. Okay, so I eventually convinced SEP that I was hurting service, and they paid me in March or April of 2013. However, I went to Veterans Affairs while I was waiting for SEP to get off their arse and do something, fix it. I went to Veterans Affairs and said, listen, what are you going to do about this? Listen, these son of bitches should have paid me from my date of medical release because I was automatically supposed to get the Service Income Support Insurance Plan. And I'm not getting that. What are you going to do for me? Now, they put me under a psychosocial rehabilitation program, which should have helped me getting the earnings loss benefit, but they didn't send me the money. They just put me into the program. Now, my point about what I thought about last night was, because I became sicker, I never kept in contact with them, and then they kicked me off the earnings loss benefit, the rehabilitation program in July or August of 2013. Now, by that time, I had been approved for the Service Income Support Insurance Plan. Now, my point about my revelation, the light bulb going off over my head last night, is that Veterans Affairs says we don't have to pay him. He doesn't have to be in our program because he's in the SEP program. I think that is playing a key part in why I don't get anything from Veterans Affairs. Because by the time March of 2013 came along, I was approved for the Service Income Insurance Plan finally, and they have a vocational rehabilitation program. Now, I was under the psychosocial rehabilitation program with Veterans Affairs, and if they were doing their homework, they would have realized that you're supposed to be in both. You can't really do vocational rehab unless you're completely healed. Like, that's just ars foremost, right? Ars foremost. But from their technical, legal, trying to save money viewpoint, they just looked at this and said, well, why would he complain? Even if we kick him out the program, he's in another program. Tell me I'm wrong. If you think that I'm wrong, put up a comment that I'm wrong. I think that this happens many times. What are you complaining about? You're already getting this much money from these people, so, what do you expect? Now, the problem is, going back to what Arnold says, this is a racket, okay? You are entitled to your non-indemnity and contributory insurance that you bought with your service and or premiums, in addition to your compensation for your personal injury that Veterans Affairs provides. So if Veterans Affairs provides a pension, you get your pension plus SEP. If Veterans Affairs provides the earnings loss benefit or the income replacement benefit, you get your income replacement benefit plus SEP. The reason being, that's the common law. The common law says that you had to get your insurance plus your indemnity. Your insurance is non-indemnity, not compensating, and your indemnity insurance pays you to make you whole, and the other payment is above that. It's simply paid in contract because you bought something. Now, the government, not wanting to pay too much money, have come up with this absurd theory that they can overrule the common law. The common law can be overruled, all right, but by the provinces, not the federal government. The provinces hold the jurisdiction over the property and civil rights, and if they wanted to come up with some kind of a compensation scheme like workers' compensation, they can. That's where workers' comp comes from. Workers' comp is a provincial invention, and it's a no-fault insurance, or maybe it should be called automatic fault, because in order to get a payment from your employer under, if they didn't have workers' compensation, you would have to prove that they did something that was against the law, the common law, the duty not to harm you, and then you'd have to prove that you had damages ensued. Instead, they made it a much simpler system that if you're on the job and you become injured, we won't worry about proving fault, and you will get your workers' compensation. It has a 98% approval rate. Now, that's in a perfect world what should happen. Workers' compensation is no gem either. People that get killed and more serious injuries, they get screwed over. When they have this 98% approval rate I'm talking about, most of the claims are short term. Cut a finger, something like that, right? Like when I was working in a fish plant in Lon in 1981, somebody cut their finger. Because of that, they had a week or two without work, and then they got workers' comp. That's where the majority of claims come on the workers' compensation system. Now, I have my uncle's wife's brother fell down and he went through and an ice auger took 2 legs off him. Now, studies have shown that people that have had serious injury get paid less in the long run than if serious injury and death get less, because they got to pay people over a longer time and they don't want to pay. They make stricter rules, right? So Carl, his name is Carl Tarrant in St. Lawrence. So Carl lost 2 legs in a fish plant in St. Lawrence, and that was in the early 80s, right? And he could have died. Losing 2 legs, you're going to have a lot of blood spurt out and shit. Paul Franklin know about that. He died and got brought back. He had 2 legs lost in a car, in an IED or suicide bomb, he called, I guess, in 2005 over in Kabul. Now, I brought up Paul because I was telling him about the reverse illness. Myself and him are in agreement on that. Myself and Dennis Manuse are in agreement on the security of the person and the psychological harm that the government does to us. Think about this now. Let's look at this through what I said about the lens of equity again. Okay. I put in for a whole bunch of disability awards. And I did it because I said to myself, listen, if I put in for something and there's only a very loose, very weak link to my service, and they tell me, no, I don't give a shit. So I put in for everything. Now, that changed when the first group, because I had a whole bunch of conditions, I got like 25 medical conditions around me. So the first group, because VAC grouped them into 3 different groups. Don't ask me what they are now. Some are mental health and some are gastrointestinal and whatever. Anyway, when the first group came back, I had the devil set to me because they didn't give me a reason. So that caused me to get triggered, get my back up, and start fighting back, even if I didn't give a shit about the condition itself. I didn't like to be told no without any reason, because that is arbitrary and capricious. That is against the law. You can't tell someone no just because you're the boss in charge of this system and just no. Goddamn stupid. Now, I put all that away. I don't fight. You look at my observation post, I don't mention anything about the disability award system because to me, it's a minor award, okay? Okay? They try to say that the disability award is such a big, important thing, but you know something? The payment for the rest of the life and monthly is more important to me, okay? The service income support insurance plan, paying in addition to the income replacement benefit monthly, I can pay bills with that every month. So I view that as way more important, okay? So I have not been putting any effort into, or very little effort into trying to get my disability awards fixed. Now that is hurting me in the long run, because Veterans Affairs, they say that there are two gateways to getting payments from us: the Pension Act and a disability award. Now I don't have a disability award, so they're screwing me over. Now, because of my research, I can tell you that a 2014 report by the research department at Veterans Affairs, put out by Mary Beth McLean, they said that 1.5% of the people on the earnings loss benefit, income replacement benefit, don't have a disability award. Now, that's important to me, because they're trying to tell me I don't have a disability award, therefore I wasn't hurt in service, so therefore I'm not going to get the income replacement benefit. But according to their own study, there are 1.5% of the people that don't have a disability award. So then why am I getting such shit? Right? It comes back to they want to control everything about this. Arnold is right. They have a racket. So if you go to them and they want to control costs, they can say you weren't hurt in service. Now, if they say you're not hurt in service, then you don't get anything from Veterans Affairs. You also don't get the Service Income Support Insurance Plan under the Department of National Defense program. Now, the way I would fix this is to say that any person that's been disabled from service and they have to lose their career, they get medically released, they have to get these payments no matter what. You can forget the disability award. You can forget it. You took away that person's office of employment. You took away their ability to earn a living. You used the law to do so. Queen's Regulation and Orders 15.01, Release Item 3A or 3B. Now, in the past, according to what I've read, because I wasn't Reg Force in the 90s, but I was reading in various reports that when a person became disabled in service, they did not kick them out of the military. Okay? So they had 100,000, 90 to 100,000 people in the military, and they had enough wiggle room to leave them on the books until they're able to retire with a full pension. That was the way it used to be. Now, according to the things I've read, they said that in the 1990s they had a reduction in the force from 100,000 to 60,000, and they had an increase in the number of deployments because of UN operations. That's a recipe for disaster. You cut the military by 40,000 people, 40,000 boots on the ground, and then you increase instead of decrease their commitments? You stupid sons of bitches. What else can happen but the system is going to get overloaded? The people are going to have double deployments, too many deployments, and then become stressed out and PTSD out the wazoo and whatever, because the government screwed up in kicking out so many people trying to save money after the end of the Cold War, when the Berlin Wall came down and everybody's supposed to be hunky-dory and friends, all Hakuna Matata and everything. So instead of that, the world's gone to hell, and we've got the smaller terrorist-type organization and failed states and all that kind of shit. So instead of pulling back, the government wanted to be on these UN tours and look good to the world and Canada, and they wanted to show how good Canada is. And then they put soldiers out in harm's way. Now, the UN tours ain't the same as what happened in Afghanistan. That was a true war. And that's a bit different. Like, soldiers are designed not to do peacekeepers. Soldiers are supposed to, by design, by definition, either fight a war or train to fight war. Okay? So you are either preparing to fight a war or you're actually fighting a war. That is what soldiers do. Now, that's McKay, Supreme Court of Canada, 1980. A case about the Code of Service Discipline. And they said that soldiers were a special class of citizen in Canada. Now, the thing about all this stuff is, it seems to me that the bureaucrats and the civilians are running the show. For example, they got rid of the 20-year pension under the Canadian Forces Superannuation Act pension. Now, even in the Income Tax Act regulations, they recognize that a public safety occupation is so tough that they allow a higher accrual rate. Instead of a maximum of 2%, it's 2.33%. And you can get a pension quicker without actuarial reduction because you're a firefighter or a cop or something. Now, they don't list soldiers. I think that's a deliberate omission. Now, according to the 2007 Treasury Board report on total compensation, when they were talking about the pension in that report, they said that soldiers have such a tough occupation that they have to be able to get out early with a full pension instead of it being actuarially reduced if you take it before age such and such and years of service equal 85. Okay? But right now, they're putting their head in the sand and they're trying to say that soldiers are no different because, again, I'm not a Reg Force person, but I've been looking up the rules, and it seems to me that the Reg Force pension is not much different than the Public Service Superannuation Act pension these days. So what happened to the fact that it was like a public service, public safety occupation and you could get out early? And why didn't they have a 2.33% accrual rate instead of 2%? And then, instead of having a 2% rate, they try to tell us that it's integrated with the Canada Pension Plan. It's actually 1.667% plus the coordination with Canada Pension Plan. So again, racket, right? Now, to fix all this stuff, we need to start telling them that they can't get away with it, that pensions are property, not income, even when they're in pay. Clark versus Clark, Supreme Court of Canada, 1990. Even though the guy was getting a pension every month, it wasn't considered income. It was considered matrimonial property, and it was divided in a divorce. Now, think about that in terms of the SEP policy. Under Section 24A, they said other relevant income. Well, legally, it's property, not income. So you get a property payment every month, not an income payment every month. Now, the difference is simple. Income is related to your current service. And property, well, that's your property. That's your asset. That's yours. And they're returning it to you. Now, they can't just return your money without adding interest. So if it's higher than what you put in, that's why you get more, right? No one expects to put a chunk of money into an investment and get out exactly the same or less. That's absurd, okay? That's crazy. Now, because the Veterans Affairs people copied the SEP program, then they copied the clawbacks into the law. Now, I'm going to have another shot at my double dip clawback again before I start thinking about quitting this program, this episode. Okay, I had this idea this morning, and it took me longer than I thought to come up with a workable solution. I made a PowerPoint type demonstration, and I used cards, and I used different suits for each department. Now, I don't remember which one it was, but there's 4 suits in a deck of cards, and I assigned one of them to Veterans Affairs Canada, one to the Department of Defense SEP program, one to the Canadian Forces program. Now then I started showing how they were taking all these other payments into account. And then I said at the end, here's what should happen. So I used Sean Correen's case. So I used, the 10 of spades or something, because he was getting a payment of $1,000, 10 being 100, times 100,000. At the end of the day, see, they're doing all this complex interactions with cards flying here and there and all that. What needs to happen is the person needs to get what they paid for. So if you pay into the Canadian Forces pension, you have to get all of your Canadian Forces pension back. That's your property. You pay into the Canada Pension Plan, you paid into that, they have money taken off your check and they sent it into the bank, and then you served during the career and you get your pension, you had to get all that money back. You can't take into account the Canada Pension Plan with the Canadian Forces pension because they're 2 different pensions. You had 2 different acts that authorized it, and the only reason that they take it into account is because Canadian Forces Superannuation Act Section 15.2b says they can. But I say that that is constitutionally unlawful because it isn't, they can't affect our property and civil rights because they're the federal government. Now, they should know this. I would probably say they do know it, especially because I've been telling them about it for 4 or 5 years. Right? So they know about this and they're looking the other way. Now, the Service Income Support Insurance Plan is a contract of insurance, allegedly, and they want to take into account property by calling it income. They call it other relevant income in Section 24A. Well, first of all, you can't do that. your non-indemnity and contributory insurance program. Now, in the common law, that means that you cannot take things into account and you cannot take other things into account. That is the nature of a non-indemnity program. Now, if they had been an indemnity program, they would have the right to take into account other indemnity payments. And that's where they're trying to get around it. In 1984, they had a case called Gibson versus Sun Life, or Sun Life versus Gibson, 1984, Ontario Superior Court. Now, in that case, the judge invented a new form of insurance called partial indemnity. No such fucking thing. Okay, you have two kinds of insurance. Indemnity, and that's where you can ascertain the value of something that was lost or destroyed or whatever. And non-indemnity, like life and disability insurance, where you cannot put a value on something, so they sell it in terms of a contract. We'll give you 70%, 75% of your income on release. That's a formula. A formula in a contract is proof that it isn't an indemnity, because you don't have to prove how much you lost. If you had to prove how much you lost, that would probably be an indemnity insurance, you see? So you could have an automobile insurance, or you could have a fire insurance, or you could have whatever insurance. Now, there's a really good case. If you look through my observation post group, look up Glynn versus Scottish Union Insurance, Ontario Court of Appeal, 1963. And they gave a really good synopsis of the way insurance works, right? And they said that sometimes they sell it by its type of insurance, like life covers life. Sometimes it goes by the risk that you're trying to insure against, like fire, right? So that case had a really good synopsis of how insurance works. I mean, that's how come I know so much about this. I've been reading cases about insurance law, right? Now, the thing about pensions are also kind of like insurance, you see? So, back in 1875, there was a case called Great Western Railway, Bradburn versus Great Western Railway, or Great Western Railway versus Bradburn, or whatever. But he had a 31-pound insurance policy. He became disabled after he got hurt in a railway accident. And after the railway lost, did you cause this accident? They wanted to say, well, we don't have to pay this man because he has insurance that is going to indemnify him for his injury. So the judge said, you know, he put the money, the premiums, into this insurance to save for a rainy day. He could have used those premiums for something else. If we allow you to take into account his insurance that he got, which is not really for sure, it's not certain, he only gets it if he suffers an accident, then you are appropriating his premiums and you are saving at his expense. And they said, you're not allowed to do it because this is based on the contract payment that he gets. He's not getting the insurance because of the event that caused the injury. He's getting the insurance because he contracted with an insurance company and he paid premiums to get the insurance, and that's what it's being paid in relation to. Now, that's what the government is ignoring, you see? The government is ignoring common law, which says that you are entitled to your insurance that you bought and paid for, in addition to your injury payment, which is supposed to make you whole. So you are supposed to get something like the Pension Act, which is supposed to make you whole. And the 17SEP program is supposed to be gravy on top of that because you paid your premiums. I don't like to use the word gravy, but I am going to use it because everybody understands. Okay? So that is the gravy on top. You are allowed to get both. In the Cunningham versus Wheeler Supreme Court of Canada 1994 case, the judges said, there really isn't a problem with double compensation because a non-indemnity payment doesn't compensate. Understand? You get the payment from 17SEP and it doesn't compensate you. You get the payment from Veterans Affairs with the Pension Act, it does compensate you. So you get one compensation payment, you get one payment that doesn't compensate you, and Bob's your uncle, everything is kosher. Now, if you were getting two payments and it exceeded what you lost, that would violate the compensation principle in tort law and insurance. So you are not allowed to get more than what you lost. But the thing is, they want to save money. They don't give a rat's ass. I tried not to curse so much. Okay? They don't give a shit about us. The problem is really between the insurance companies. Okay? Let me give you an example. Gerard served 27 years in the military. After he got out, went to work for Canadian National Railway. Bought a group insurance, Great West Life. Now, when he became injured in a car accident after, they then took into account his Canada pension plan at both the Canadian Forces Pension and Great West Life and Veterans Affairs, but I'll get that later. But because pensions are like insurance, they're different, but they're like insurance because that's how they got brought into cases, and that's what I was trying to lead into. Okay, so the insurance is not allowed to be taken into account for damages. So the people that were paying the insurance, the damages, the insurers, they wanted to try to take pensions into account. So the judges shot them down by comparing insurance to pensions. They said pensions are much like insurance, and based on that, we're going to rule that they're also non-indemnity and contributory. So because the pensions and insurance are off limits for people that pay damages, that is why I believe the Pension Act doesn't touch the Canadian Forces Pension or the Canada Pension Plan. You see? So the Pension Act respects the common law, where a pension or insurance is not allowed to be taken into account with an indemnity payment. Now, the new Veterans Charter does not respect the common law because it takes into account a non-indemnity payment like a pension or an insurance. Now, adding insult to injury, as I said before, is that they take it into account despite the fact that the other department took it into account. Now, you can't tell me with a straight face that both departments can take it into account, one under contract law and one under statutory law. Something has to give in that situation. If you take it into account under contract law, under the Department of National Defense Insurance, and then you try to take it into account under statutory law, the person at the government, the Veterans Affairs Department, they should look at that, and because they have a program arrangement in place, they should, if they have any questions, call up the Department of National Defense, and they have consent forms up the yazoo, and they could say, listen, this person getting SISIP? Yep. How much are they getting? And then they tell them, are you taking into account the Canada Pension Plan? Yep. You taking into account the Canadian Forces Pension? Yep. Okay, then we can't take it into account. Yep. And that will be it. But instead of that, these sons of bitches at Veterans Affairs are taking into account the Canada Pension Plan and the Canadian Forces Pension, despite the fact that the Department of National Defense is doing it. Now, I predict that they're going to upset the apple cart that the Canadian Life and Health Insurance Industry Association has, because they have a policy where 50% each is all that they'll take. So if the exact same situation happened with two private insurers fighting over the money, and the person being caught in the middle, then the insurers want to cover their arse, and they only take 50% because then the person is not going to be so pissed off that they'll go public or go get a lawyer or go to the member of parliament or someone, because they're only losing the equivalent of what they got. But the government, being the government, they're taking 100% each and trying to convince us, trying to gaslight us, trying to tell us that their racket is okay. Well, again, I'm trying not to curse, but I'll put the visual one up. They need to be held accountable. And the thing is, this occurred to me the other day. Tell me I'm wrong. Click on like if you think I'm right. Why should our tax dollars be paying an employee of Veterans Affairs to willingly break the law? You want to break the law? You do it on your own time. Don't go using our tax dollars for that employee to break the fucking law. Okay? We're talking about the common law, Bradburn Rule. We're also talking about Canadian Forces Superannuation Act, Section 83, Canada Pension Plan Act, Section 65.1, Financial Administration Act, Section 67. Listen, you don't want to get caught breaking the law. You are in charge of writing the law. Don't write the fucking law. Okay? Don't put the Canadian Forces Superannuation Act, Section 83 in there, which says nobody can touch that money. If you want to be able to touch that money, you leave that law out. But the thing is, it serves a public purpose. Okay? Let me explain why. I got some of this from the Zurich Supreme Court of Canada case, Zurich Insurance Supreme Court of Canada case, 1990. There's a very important public policy reason why insurance and pensions had to be untouchable. You buy a car from Ford, GM, Chrysler. you say fuck that and don't pay the payments. They go to court, they get a judgment order, they then send it to your pension because they know you're a Canadian Forces veteran. They then send the money that is supposed to look after you in your old age, your retirement years, your times of vulnerability. You don't have an income. And they then send the money that's supposed to go to you, which is your property. And they send that to Ford, GM, or Chrysler. Now, what are you going to do in that situation? You don't have any money to live on. You're going to go knock on the door for the welfare system, and you're going to say, listen, my pension got took by them sons of bitches at Ford or GM. I ran into some trouble and I couldn't make the payment, and they went to court, and them sons of bitches got a judgment order, and then they sent it to the government, and then the government honored it, and they took my property and sent it to them, and now I got nothing to live on. And then they put their hand out and say, I want some money to live on. What these people are doing is putting the government and the rule of law at risk. Higher taxes would result if that situation was allowed to happen. So there was one really well-respected, known author that said, they should be crown debts like the pensions and insurance and stuff that should not be off limits to creditors. Now, I just explained why it's off limits, but they think it's part of a thing called residual crown immunity, and that it's from the old days that you couldn't sue the king, and therefore they want to change it because, well, there's no king anymore. We have a parliament of elected members of parliament, so they want the crown immunity removed. And I called his office once, Vern Krishna, about the Income Tax Act stuff, and I was hoping that he would help us out because, he's Canadian and soldiers put their life and limb on the line for Canadians. So I was hoping to guilt him into trying to give us a freebie and weigh in on the taxes. But if I recall correctly, he was the one that might have, well, if I'm wrong, well, I apologize. But somebody, some real big expert was saying that they should get rid of the residual crown immunity. Now, the problem is that there isn't a real problem with residual crown immunity, that there's a public interest in making sure that people's savings for retirement are sacrosanct. Okay? You have to make sure that people get what they paid for. So it's not just the legality thing, it's the equity thing. What am I going to live on if they take all my money? If some creditor takes all my money that I saved up for retirement, then I'm going to tell my kids and everybody else, listen, boys, spend it while you got it, because you can't trust the government. You can't trust that it'll be there when you need it if they keep doing this kind of shit. See? So I'll end her on that note. Look, I'm not out there to get more money for Matt Edwards or more money for Arnold Murphy or Donald Bohan or whatever. This is about respecting the rule of law, respecting the common law, and getting what you're supposed to get. If you get what you're supposed to get, you don't have to get anything else. Just get exactly what you're supposed to get. You've got no reason to complain then, okay? So if you make a complaint after you get everything you're supposed to get, you're a goddamn bitcher or a whiner or something. Which reminds me of a funny story. I'll leave it at this anecdote. When I went up north teaching in Webequie, Ontario in 1991, we had a conference in Thunder Bay, Ontario, and one of the people that were there from Indian Northern Affairs took us aside at the beginning, or maybe it was right up there at the stage. They said, beware the bitchers and complainers. Now, the guy was talking to me later, and he said, listen, put everything in writing, he said. Put everything in writing. If the government doesn't get it in writing, then nothing will ever happen. Now, a few months later, instead of him being a teacher advisor, he was acting manager, and here I was taking his advice, sending in complaints in writing, because he told me to. Now, he was up on a conference in our town, and then he took me aside and put his hand over my shoulder and said, Matt, off the record, if you're looking for a job reference later and someone asks about it, that we might have to say, listen, off the record, this guy is a bitcher and a complainer. He's always complaining about things. And I was shocked because here's the fellow who told me to put everything in writing. And then when he was the one who had to respond to the questions in writing, he complained to me about it and basically threatened to give me a bad job reference. I mean, these are the kind of things that make me fucking laugh, right? All that guy had to do was, I don't know what he had to do. He probably shouldn't have told me to put everything in writing because I took his word as gospel. But the thing is, it is good advice. But these days I'm more out by it. Like, I got to get around to doing a complaint to the Public Service Superannuation Act people because I bought back my time on the leave without pay, and I never saw a benefit from it. Now, I recently put two and two together and did the same thing, and I wrote a letter to the Canadian Forces Pension because I bought back my Canadian Forces time from 1999 to 2007, and I saw no benefit from it because they took that pension into account at the Service Income Support Insurance Plan. Now, when I did up the draft, you can have a look at it on my observation post group because I post everything there. I forgot a very important point. I have to change it. I had to edit my letter. I'm hoping they fixes up my Veterans Affairs stuff now. If they do, I'm wanting the Canadian Forces people administering the Reserve Force Pension Plan to tell Veterans Affairs Canada that they can take a flying fucking leap if they want to take into account my Reserve Force Pension Plan because A, the Canadian Forces Superannuation Act Section 83 protects it, but B, it's already being taken into account by SISIP. And if SISIP is taken into account, then Veterans Affairs obviously can't take it into account again. Now, the way I look at it is that the people that have these home acts, okay? If you're the person administering the Canadian Forces Superannuation Act, that's your home act. If you're the person administering a workers' compensation system, then your home act is whatever law that authorizes your place. Veterans Affairs Canada, their home acts will be a bunch of them, right? The Department of Veterans Affairs Act, the Pension Act, the Veterans Wellbeing Act, the Veterans Healthcare Regulations, all these different things. Now, if you don't enforce those acts, then people are going to break it. And the Pension Act Section 30 should have had Veterans Affairs contact the Department of National Defense and saying, listen here, guys, you got it in your contract that you can take into account the Pension Act. I would like to remind you that the law applies to you as well. And Pension Act Section 30 says you can go fuck yourself. Now, we wouldn't have had the Manouche case if they had have enforced Section 30 of the Pension Act. We wouldn't have the support law mess if the judges across Canada were told by Veterans Affairs, listen here, Judge, you're a Canadian citizen. You're bound by Canadian law. As such, you are also required under the Statutory Instruments Act to take judicial notice of the law that we pass. Now, we passed Pension Act, Section 30, in the past, and you are a Canadian judge, which is a Canadian citizen, and are bound, required, to take judicial notice of Pension Act, Section 30. Now, if you have a veteran like Matt Grassi that comes across the judge's podium, whatever you call it, anyway, she took into account his Pension Act pension and grossed it up for income taxes. Now that ain't fair, okay? You cannot take a person's personal injury damages and convert it for the benefit of somebody else. What the judge needs to do is, first of all, obey the law. Secondly, recognize that the Pension Act and any other payment paid by Veterans Affairs is like tort damage awards, meant to make a person, an individual, whole, and not to be used for somebody else's benefit. Okay? That's what they need to do. They need to be reasonable. Geez, I won't need to do one of these on support law if I keep going into it a bit, but I promise, one of these days, I'm going to touch that political minefield issue. I'll leave it at this, though. I called up Matt Grassi's MP. I didn't realize that she was the minister for the status of women. Or maybe I might have chose my words differently. But I was talking to one of them staffers up in her office. And the staffer had the gall to say to me, sounds like to me you're trying to get more money for the man than the woman. And that earned the man a 10-minute lecture about what the fuck he could do with his fucking opinion, because I would not do that for anybody. It was about the law, about obeying Section 30 of the Pension Act, about obeying the make whole part. But I stand by giving him a lecture, but I don't think he took it to heart. I've been trying to get Veterans Affairs to intervene in these cases, and that's getting exactly nowhere. I think because it's a political minefield, right? Look, in the past, in a divorce, women got treated very badly. Women were left poor, and the government brought in rules to try to fix that under the provincial system. Now, what they're not doing is they're not taking into account the common law and the federal statutory law, and they're just doing what they want to. All the person in Matt Grass's case had to do was look at the Family Law Act of Ontario, see that personal injury damages are not to be included for support. Then they had to make a connection in their head and say that the payment from Veterans Affairs is exactly the same as personal injury damages. And then the person didn't even have to bring up the Pension Act, Section 30, Financial Administration Act, Section 67. All they had to use was their noggin, common sense. But they didn't. Now, one of these days, and this is a touchy issue because, like I said, women have been mistreated in the past, and the government has responded with all these laws. I've seen it in many cases. In one of the cases I always cite, Beattie, B-E-A-T-T-I-E, versus Ladiseur. I used to think it was Ladicour, but I saw that it's spelled differently than what I thought. In 1995, the lady was owed $300,000 in alimony. She took the man to court. He was left the country. She wanted to get an equitable receivership to go after the pension, the Public Service Superannuation Act pension, which is the only thing that she could get. The Department of Justice intervened in that case, and they said, you know, Judge, if you grant this lady her wish, then you will be giving the government an order to break the law that it wrote. Now, I took those words to heart. I agree 100% with that Attorney General. If the government took the time to write these laws to say that nobody can touch our pensions, nobody can touch our assisted long-term disability insurance under Section 39.3 of the National Defense Act, it states that non-public property is inalienable. Now, that has come up in support law cases. People have looked at a disabled veteran who's been medically released. The medical release resulted in an automatic SISIP. Then the person's getting divorced, and they're going through the divorce case, and the judge says, well, we're going to take into account that income. It's not income. It's not even income replacement like they say. It's insurance. It's insurance proceeds being paid monthly to the person who bought it, and it is not income. You can't convert it to something just because you want to, which is what the government does, right? Insurance is property. Property, you don't even get it unless the risk happens. So you're harming somebody who is disabled in service. And I can link that right back as my final point to the Charter of Rights and Freedoms. Section 15.1 of the Charter of Rights and Freedoms states that no burden will be placed upon a person, and I'm going to look it up because I got it there in front of me. Every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Now, you get the Canada Pension Plan because you were disabled. You get the Canadian Forces Superannuation Act pension early because you're disabled. Then the Service Income Support Insurance Plan takes into account those two disablement pensions and insurances, and they reduce their legal liability, which places a legal burden on you in contract. Now, as I said before, the government cannot contract out of the Charter. Somebody, might be me, could be you, somebody should take this to a court of competent jurisdiction under Section 24.2 of the Charter. I'm going to look down and see if I can find it and read exactly what it says. 24.1. Anyone whose rights or freedoms as guaranteed by this Charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. Now, it's actually 24.1 of the Charter, not 24.2. So, we can go before a judge, we can lay out our case, we can say what's happening, and then we got to hope that the government doesn't use the notwithstanding clause. Because the government can use the notwithstanding clause, but it shouldn't. I'm going to leave it on that note, and thanks for watching again, people, and I'll try to make these things shorter. But, you know, I don't know, maybe people like it where I'm just rambling. Maybe it's more entertaining, although I don't mean to be an entertainer. I almost broke down when I was talking about that Pension Act. Anyway, thanks for watching.